Assalamualaikum. Hello, my name is Muhammad Ravidi Yusuf. Alright, for the identification of case, we chose Teknojaya Construction Sedia Berhad versus Teliana Plantation Sedia Berhad as our case study on the Malaysian construction case law based on practical completion or defects. We chose defects as the construction disputes that were based on civil suits cases. Generally, a construction defect is defects in the building processes, whether in design, materials, or workmanship, that causes a failure in some component of the structure being constructed and causes harm to a person or property. Moreover, the civil suite number is MYY 2022 13/6 of 2013, and this case was went to High Court at Sibu, Sarawak, whereby the plaintiff is Teknojaya Construction Sedia Berhad and the defendant is Teliana Plantation Sedia Berhad. Alright, that's all from me. Now I would like Alicia to present about the next detail.
Hello, Assalamualaikum. My name is Alicia Timosa and I will be explaining on the detail of the law case that we have choose. A contract between plaintiff and the defendant called for the completion of 2 stores and 2 blocks of quarters at the defendant's palm oil estate. Later, the plaintiff had completed the construction of the first store. They had issued the defendant for a letter of demand. However, the defendant did not deliver to the plaintiff the construction site for the remaining work with piles to ready-built materials from the workers' housing. The plaintiff sought payment of the remaining contract balance for the defendant for breaking the terms of the agreement. This is due to the fact that the scope of work for the employee's quarter was missing from or excluded from the aforementioned agreement until it had already expired. As for the defendant, they assert that there was a defect in the plaintiff's work and that there was a loss issue as a result of the plaintiff delaying the construction of the store. Both the plaintiff and the defendant provided statement when this case was brought before the court to explain their respective issues.
Thank you for the previous presenter. Right now, I want to talk about the fact of the case between Teknojaya Construction and Teliana Plantation. This case is on the construction of 2 stores and 2 blocks of workers' quarters. So we'll go into deeper to this topic. Firstly is on behalf of the plaintiff. They claim that the defendant didn't give the allocation of the work on the second store. With that, the plaintiff unable to carry out the works. They have clarified that they do not want to build the both stores side by side. So the defendant breached the contract to not clarify or give a proper information to the plaintiff. Moreover, plaintiff's second claim is the workers' quarters have been omitted from the said agreement, and it was not within the plaintiff's work. It started with the defendant failed to complete the piling works and made the plaintiff unable to carry out the works. So the agreement have been breached with the defendant appoint another contractor. Next is the counterclaim between the defendant. The plaintiff have been terminated by the defendant because they have been abandoned the works for the second store. The plaintiff have breached the terms of the agreement. The result is the delay towards this project. Lastly, defendant's second counterclaim. The plaintiff is the one who need to carry out the piling works, and the plaintiff had failed to do it. So this is the reason that defendant appoint another contractor to carry out the works. On top of that, the defendant also claimed that for the special damages of the total loss of the first store due to the poor workmanship, and then the damage of the work program caused by the plaintiff is the reason why the delay of the construction of the second store. So that is the fact of the case for this topic. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. I am Ainulisa Balkis binti Harizan. Allow me to continue this presentation with the decision by the court. Firstly, it is obvious that the defendant had broken the terms of the agreement from the beginning because they neglect to inform the plaintiff and turn over the site so that the construction on the second store could continue. The court then upheld that the piling work was outside the scope of the plaintiff obligation under the contract, demonstrating that the defendant was still in default even after the plaintiff had completed the first store and turned it over to the defendant, or even before the plaintiff had removed the last of the building material from the first store. Next, the defendant failed to call the maker when presenting evidence during the trial, which contradicted the defendant's claim that the first store was never supplied to it. As a result, the court accepted the testimony of the plaintiff expert. This makes the defendant unable to demonstrate the cause of the first store failure. After that, according to the other defense by the defendant regarding the improper and insufficient piling works by the plaintiff, the court ruled that the defendant did not provide the evidence necessary for the issue, which caused it to be rejected. The reason for this is because the defendant never raised the issue in its defense or counterclaim, making it an afterthought. Lastly, the court would dismiss the defendant liquidated and ascertained damage LAD claim against the plaintiff as being without basis. Since there was no supporting evidence at trial for the defendant's claim of general damage and or losses, the court also rejected those claims. Considering the balance of probabilities, the defense counterclaim is disproven and is consequently dismissed. Since the defendant fundamentally violated the terms of the said agreement by refusing to grant the plaintiff was entitled to claim damages for breach of the said agreement.
We're moving on to the reference. The defects clause that has been referred to is 50.4 Schedule of Defects, which stated that any defects in the works that emerge within the defect liability period shall be stated by the architect in a Schedule of Defects within 14 days after the defect liability period has ended. However, the defendant, unable to prove any evidence in terms of an official letter or pictures, stated that the plaintiff had to rectify any defects works on the completed first store. The defendant claims that the contractor's action to treat the agreement as an end without informing them is false because the plaintiff has submitted numerous letters from July 2012 until December 2012 without getting any feedback or reply from the defendant. Plus, the defendant has fully paid for the completion of the first store without any disagreement during that period, showing that the defendant is satisfied with the works that have been carried out by the plaintiff. Other than that, Clause 24.1 loss or expense caused by matters affecting the regular process of the work also referred, so specifically to Clause 24.3b, matters materially affecting the regular progress of the works. The defendant made a counterclaim regarding general damage and or losses against the plaintiff, however, was dismissed by the court due to the date of the completion for the first store already exceeding 6 months of defect liability period, despite purposely delayed on giving the second store site profession to the plaintiff.
Thank you to all my team members. Hello and Assalamualaikum. My name is Noafidimiti Idris. I will hereby conclude all the lesson learned that we have gained from this case study. The first one is timeline. Timeline is very important in every industry. It advises us to continually be aware of the project's progress and timelines. All the timelines have been stated in the contract documents, so we need to obey with all the instructions that have been stated. The second one is evidence. Every work done can be made by doing a joint valuation which considers by client, main contractor, consultant teams, or any parties. Evidence is really needed even by a recording video or any related in order to avoid any fabricated proof in the future. The third one is communication. In every organization, communication is necessary in order to prevent any misconceptions. An employer can ask to their workers about the things that they are not satisfied or did not understand before making an assumption. If miscommunication happen, it will make both parties in a bad terms. I think that's all from us. We hope that we have learned and gained something from our case study to avoid the same thing happen in the future. Thank you.